We've received quite a few questions in the lead up to this webinar, and we'll get to as many of those questions as we can during the time we have together or as a follow-up. I would like to point out that the information that's provided in the webinar today is general information only, so it does not take into account your own particular work situation or your objectives and needs. Before acting on any information contained in this discussion, you should consider the appropriateness of the information having regard to your own objectives, work, and financial situation and needs. Now, Julie, let's start by looking at the changes to the Privacy Act that came into force a couple of months ago. Tell us, what led to those massive changes?
I think what has been happening over, particularly since about 1990, is, you know, a big push towards information economy, and obviously around about early 1994, three to four, the availability of networking programs for the community. So the issue became, not that it wasn't there before, but it really pushed this issue in light of, you know, sort of privacy, I suppose, and information and data collecting and those sorts of problems. And the government then became quite active in looking at, you know, how data, the collection of data, the use of data, the disclosure of data could be better protected from not only a business point of view, but from an individual point of view. So the issue of privacy really has not historically been new, but certainly with technology, the type of technology that is available now is now, you know, quite a focus. So data privacy is a hot topic for Australian business today. You don't have to go far to sort of see that even internationally, for instance, the European Court has just, you know, sort of looked at the right to be forgotten, yet the Google, and since that sort of was declared, I suppose that Google has received about 12,000 applications, you know, to instigate that right. So, I mean, I'm just saying that this is not an Australian issue, it is a global issue, but of course, you know, there's got to be Australian solutions in regard to that. So that just gets back to my next point, and that is the law does change from day to day because our, I suppose, information economy changes from day to day. There are different needs that have to be considered, and those needs then, you know, sort of have to be protected or implemented or whatever one does at a national level, as well as taking into account global issues. So privacy, the issue here is that because we have a federal system of government, there has been harmonisation of a lot of these approaches to law, but there still needs to be a certain amount of consideration when you look at this area of protection of state legislation and federal legislation. However, as I said, there has been this harmonisation, and the federal government has more or less taken over this area to a large extent. Hence, prior to you know, the Australian privacy principles coming into being enacted or coming into the Act, you had a number of information privacy principles that were operating at both state level and federal level, and it was a very complex, confusing system. You also had a difference between public sector privacy protection rights and private sector. Now, I said to you that, you know, this has been a concern of government for a long time, on and off. So obviously in 1988, when the original Privacy Act was passed, that was a concern then. You've had various amendments since then. You've had you know, which I'll talk about in a minute, but it's been a continuous sort of a show, I suppose. So it is a concern for both state and federal governments. State government privacy requirements need to be considered under certain circumstances, as do the federal privacy requirements. The interesting debate has been, what do you mean by privacy, for a start? So there is a lot of debate around about the theoretical or the conceptual idea of what are you looking at when you look at privacy. Very, as I said, lots of debate about that. However, I suppose the bottom line for a lot of people is consumers are very concerned about their privacy. There were a number of major research projects, you know, that were done by the government looking at people's concern. A lot of those projects were in relation much more to health information when the electronic...
When did they start the process which eventually became a legislation?
Look, they started the process in about 1998, and basically that is when the idea of the information economy really started to, you know, come up. In 2000, 2001, the Health Connect was then put in place and so forth. So this has been a debate that's gone on for quite a few years. And as I said, you know, there's been a lot of discussion about what do you mean by privacy to begin with. So these research projects that were looking at consumer, you know, concerns have been actually run over a number of years. And I suppose the outcome of it is that people are really very concerned about their privacy. That's the bottom line. However, it's an interesting debate, because if you're looking at privacy, you know, one side of the coin is, do you protect individual privacy, or are we living in an information economy where information is an asset? You know, we all collect information, government collects lots of information, and businesses. So in a way, information economy runs on free flow of information. So you have a real tension between, do you protect individuals' rights or as an individual right, or do you sort of bundle everything together and say, well, it's really a collective interest that we're looking at, and that maybe the economic collective interest should take precedence over the individual, you know, sort of privacy protection. And that debate still goes on. It's a tension. However, you know, the government has seen fit to look at the privacy principles. It has commissioned several very large reports from the Australian Law Reform Commission, which have reviewed Australian privacy law in terms of what's happening, and there's been numerous reports. The government committed itself to implementing a lot of the recommendations that the Australian Law Reform Commission had about privacy, not just health, but credit privacy, consumer privacy. So, you know, this is a product of many years of development. It's not just something that has happened overnight.
There seems to be so much at the moment about, you know, a government of one persuasion will start a process, and then by the time that a law comes in, the government of the other side is in power, and then they say, well, actually, we're going to dismantle that. Am I right in assuming that this is actually one of those issues that transcends party politics as opposed to a lot of the other legislation?
I would like to think it does. The recent budget sort of paper that was put out by the current federal government, you know, did not really mention terribly much about electronic health records and privacy and this sort of thing. Now, that's not to say it won't become an issue in a couple of years' time, but there are certain constraints, I suppose, within that budget, which I think are a little bit worrying, and that is about the Information Privacy Commissioner. And, you know, there seems to be, when you have restraint in budgets, these, you know, bodies, and of course the Information Privacy Commissioner, that is what they're the overview, the oversee. This is the organiser or the body that puts the guidelines in place. They're not kind of getting rid of it, but they're suggesting that they, you know, I don't know, bundle it together with some other, and I think the interesting thing with this, Ray, just to go back to the political question, this all came up originally because of a coalition government. And so the coalition government, I think when Abbott was health minister at some stage, this all, you know, this whole thing about electronic patient records or privacy was all an initiative of that. So you've had various governments following that initiative. We are now to the stage where I'm not quite sure what they're going to do in regard to any new policies. But it is interesting. It was a coalition initiative to begin with. Yeah. Yeah. Yeah.
Everybody has a stake in where.
Yeah. Yeah. So the important point, I suppose, is now that the Australian privacy principles are there, they are part of the privacy legislation. Just one other point I want to make is that when you talk about privacy, protection of privacy, you are really talking about two categories of this. One is the provisions that make it an offence to disclose information, and the other is laws that specifically regulate the collection of information. So it's a bit about a balance again between a person's, you know, sort of right to be able to access information that is held about them. And this obviously you can see in legislation like freedom of information and these sorts of pieces of legislation. But then there's legislation that protects or, you know, specifically regulates the information. Now, again, the privacy principles, the APPs, are principle-based law. So they're designed so that they are flexible. And so part of that is that they are technology neutral. That's how they're seen. So they apply whether it's written on a piece of paper, you know, or in fact through electronics. That was the suggestion or the recommendation by the Australian Law Report Commission, and that was taken up by the government. So you can see the timeline. You can see that in 1988 the Privacy Act was enacted. It's been amended numerous times. It basically just covered public sector privacy concerns at that stage. In 2000, big debate at that time about actually bringing in the private sector. And so the national privacy principles were developed during that time. So the Privacy Act itself had informational privacy principles, then the national privacy principles came into place. So what you see in terms of the privacy amendment enhancing privacy protection is just, you know, a new unified national set of principles that cover both the public and private sector now. So you don't have to keep looking elsewhere. Part of that phase of, you know, implementing privacy protection, the government decided when it had the recommendations from the Australian Law Reform Commission that it would do this in stages, and one of those stages was about that, which is reflected in the Privacy Alerts Act, which is about a mandatory obligation to inform the Information Privacy Commissioner, you know, or the Information Commissioner, if there has been a breach, a serious breach of some kind. So that was brought forward. That was a second phase initiative, which was considered after, you know, various PlayStation cases and things like that. So just to run through this, there are 13 unified privacy principles. Basically, they more or less pick up on the IPPs and the MPPs. So they're not sort of separate. They bring it together. So Principle 1 is about that there's an open and transparent management of personal information. I won't go through all of them, but I think basically there's a number of, if you look at how this is organised, it is about promoting the protection of the privacy of individuals. It's about recognising the balance with interests of entities. So under the privacy changes, it's been defined, so organisations and agencies are now APP entities, so there's been a broader definition of that. Free flow information, you know, that goes elsewhere outside of Australia. It's not just about Australian citizens. That also has been expanded. So a number of the definitions have been expanded in this. So what we've got is we've got principles that promote balance, are reasonably consistent, responsible, transparent handling of information. It's about efficiency. It's about free flow. It's about a complaints mechanism, about people being able to go in and see what's written about them and maybe changing that. So that picks up on that other point, and the international obligations. All right. So make a comparison. This does align with other legislation. As I said, one of the principles allows someone to be able to access, which is aligned with freedom of information and human rights and international obligations. There are, however, quite a number of exemptions in regard to the APPs. Employee records is still one of them. The function of the Information Commissioner is now, you know, it's a very active function under Section 23 B, I think 1B. This requires the Information Commissioner can provide guidelines, which they have, in relation to the APPs. They can conduct investigations of complaints from either their own point of view, or if there's a complaint, an individual complaint. I talked a bit about the privacy amendment, which sort of adds to this, and it's about compliance and robust business focus and policy development. So there are mandatory obligations under that, but there are also, you know, sort of you could do this or you should do this, or other obligations. So I think kind of the secret of this is to sort of see that they're trying to balance individual and collective needs. They're trying to look at a flexible system for technology to be able to operate. They're not trying to, I suppose, beat businesses over the head with this or whatever. They're trying to get businesses and solutions to come up with, you know, good policies in regard, and also to think about why they are collecting information. So part of that is there's been a bit of a mentality, I suppose, that you just collect whatever you can, and because you can. Now this is requiring you to actually understand why, or to have reasonable reasons why you are collecting something, and a purpose. I suppose it's about purpose. Okay. So the last point I wish to make, and that is, I think this is a good comment. Streamlined and harmonised set of obligations that draw on existing principles. So there's no new, it's existing it fleshes it out, it maybe expands definitions. It's to ensure that standards also take into account an individual's expectation around the handling of their information, and to ensure that regulations strike a balance between the public and individual interest in efficient and effective service delivery and public safety. So that, I would say, would be an aim.
Thanks very much for that, Julie. Hopefully we're going to have time to ask a couple more specific questions when we get to the end of the presentation. And also you'll be, everyone who participates will be sent a link with some downloads afterwards, which includes a link to an interview that we did with Julie actually a couple of months ago, where she talks about a little bit more about things like some of the penalties involved. So if we move on to discussing a few other issues with legislation. Now, Dick, there were a number of changes to the Fair Work Act that came into effect in January. How have they affected Australian businesses so far?
Thank you, Ray, and you're right about that. I guess, in fact, that's only part of the story as well, because prior to the 1st of January, there were also a number of changes which came into effect, and some of them are fairly significant for most employers. I'm not going to deal with those, but I'd have to say that what's happened since the 1st of January hasn't taken place in a legislative vacuum. So specifically going to your question, I guess the most obvious and perhaps the best publicised change has been the introduction of an anti-bullying remedy system in the Fair Work Commission itself. And I'd have to say that our experience since it's been introduced has been that the Commission has been very sensitive about this jurisdiction. I guess we'd expected that, but if you have a look at their web page and have a look at the anti-bullying application area on their web page, you'll see that they've tried to address a range of problems, not just the legislation itself. And I think I'm pretty positive about what they have up there. There's not only trying to explain to potential applicants what their rights are and what they might want to do to try to seek their own remedy, but they try to address some of the potential health and safety issues associated with bullying, and also those sorts of issues unassociated with bullying, such as depression and the like. So I'm pretty positive about that. And it also appears that, at least for the moment, there's not been a huge flood of applications. I think that's a good thing. Obviously, there's more bullying taking place than that would suggest, but it does also suggest that people aren't trying to take advantage of a potential system which could be very intrusive and distressing for employers. Very briefly, the capacity in the system is to apply for an order from the Commission to prevent bullying from happening. It's quite broadly cast legislation. It applies to workers, not just employees, and that's pretty important. And it applies to employers which are constitutional corporations. The important ingredients are that the applicant, or it may be a group of workers, the applicants, have to be at work. That also means that if someone terminates from an employer, they can't retrospectively lodge an application, because these orders are intended to influence behaviour in the workplace where the bullying is taking place. It arises from unreasonable conduct towards the potential applicant, but it needs to be not only unreasonable but repeated. And finally, it must create a risk to health and safety. And obviously the normal risk for quite a lot of bullying, and it would seem to be more of an office phenomenon looking at the figures to date rather than, if you like, a building site or a factory phenomenon, is psychological injury as opposed to literal physical injury. So that they're key ingredients. There's been very little case law. There's only been just over 150 applications in the first quarter. They've all been dealt with. There's been one order issued.
We were originally expecting a lot greater numbers than that.
That is correct, and obviously one part of the explanation might be that it's new law and people are adjusting to what's there. One part of the explanation might be that people who are suffering serious injury from bullying perhaps are also unconfident about bringing this sort of application. And I think also one part of the explanation is that the Commission itself has gone out of its way to try and focus people who proceed with an application on genuinely properly being there and not chancing your arm and wanting to create problems or seeing what you might get out of it. The two sorts of things we know about the jurisdiction are that conduct which took place before the 1st of January can also be taken into account in assessing whether there has been repeated and unreasonable conduct taking place. It's not from the 1st of January what's happened to you, so it does suggest that someone who has in the past, or a group which has in the past been subject to bullying, can make an application if there is continuing unreasonable conduct towards them. And the other clear learning, I guess, is that making representative applications, particularly if you are trying to just not disclose the identities of the actual purported victims, does not seem to be permissible. There was a matter brought on. It was referred to a full bench. As it turned out, the applicant union withdrew and hasn't re-lodged an application, but I think it was fairly clear looking at the papers to do with all of that it was quite likely that the applicant union would have been unsuccessful. So I'd have to say we've had our doubts about the appropriateness of using an industrial forum for what is a very important health and safety issue, but to date perhaps some of our concerns have been shown to be misplaced. Very briefly, a couple of other key issues is that people who wish to apply alleging a breach of general protections, which has given rise to their termination, prior to the 1st of January had up to 60 days to make such an application. That is now 21 days. And the second key change in that is that if the Commission can't resolve the issue between the applicant and those caught up in the application, it generally issues a certificate that would enable an applicant wishing to pursue his or her claim to go to the Federal Court. There is now an alternative mechanism, and that is if both parties agree, then there can be an arbitration by consent. It's difficult to know how these two things have affected the flow of applications. Certainly there was a relatively high number of applications in the first quarter of this year, but it's probably a bit early to know how these are going to affect the trends in the longer term. And also there have been some right of entry provisions, amendments where the entry is for discussion with people who are members or eligible to be members. Prior to the 1st of January, if the employer and the entrant couldn't agree a location, then the Commission could determine that. That's been changed so that if they can't agree on location, then the discussions with members can take place where those employees generally have their meals, and there's no capacity in the Commission to arbitrate disputes on that anymore. However, there is a new capacity in the Commission to hear disputes where an employer believes that a union is unreasonably trying to enter with undue frequency, perhaps for disruptive purposes or the like. early days there, there's not been much there, although it's a very high bar to get an order from the Commission on that basis. Perhaps the last important thing, and I'll deal with it very briefly, is that from the 1st of January, when the Commission contemplates varying an award, it has to have regard to the Modern Awards objective. There is a new link to that now, dealing with the requirement to pay additional remuneration, broadly speaking, for employees working non-ordinary hours. That will obviously influence applications in the 4-yearly review, or approaches to vary awards in the 4-yearly review, which are focusing on things like penalty rates or overtime rates and the like. To date, the indications are that it's not being treated as a significantly different weight that is placed on that sort of consideration than in the past. But again, apart from some discussion in the recent decision on the restaurants appeal, this new limb of the Modern Awards objective has not been tested. Also, arising out of changes to the Fair Work Act, there's a new obligation in all modern awards for employers to consult with the affected employees and their representatives, if they have any, where the employer proposes to change their regular roster or their regular ordinary working hours. The consultation needs to take place in advance. The employer should be talking with the representative where there is one, as well as the affected employees, and provide information about the proposed change and when it's intended to come into effect and the like, and to invite comment from the employees about that impact, including on their domestic arrangements and so on. And the employer is supposed to give consideration to anything which is raised about the impact. Difficult to know what, if that is questioned down the track, what proof of giving consideration might look like. And I guess we've just got to wait and see. I don't think it really requires a written response or anything like that, because at times it may well just be a fairly quick conversation, and other times it might be a much more significant conversation. It's important to notice that, for example, an award provides that a rostered shift is one with 48 hours notice, and you want to alter a regular rostered shift, then the consultation process is not in that 48 hours. It's rather after the decision to proceed with the roster change is made following the consultation that the 48 hours takes place. This is fairly clear from the Commission's decision, which actually inserted these provisions in awards. Related requirements apply to agreements which are made from the 1st of January. That is, that they must contain a consultation clause broadly of this kind. Very quickly, there has been a recent decision which has clarified the situation for those employers who seek to have an arrangement where annual leave is paid on the pay cycle all the time. This is not quite the same as cashing out. Rather, you're paying the employees the equivalent amount of annual leave on top of their ordinary pay, if you like, each fortnight or each month or each week. And that discharges your obligation to pay when they do take leave, so that leave then becomes unpaid. And there was some confusion in the case law about whether this is permissible. A recent case has made it very clear that it would breach the National Employment Standards. That means that even if it isn't an agreement, it has no effect. So there are two sorts of implications, I guess. One is that it's not a sensible thing to be negotiating in a forthcoming agreement, but if you have an agreement which provides for this, you might seek some advice about what you should be doing, because as a breach of the National Employment Standards, and that's now the best law we have, that provision has no effect. I guess a key thing which is happening now and will be going on into the future is the 4-yearly review of modern awards. Basically, the Fair Work Act was based on the idea that awards would be fairly stable, then every 4 years they'd sort of be thrown up in the air, and assessed for their contemporary relevance, and then they'd settle down for the rest of the next 4-year period. It's a bit confused, I guess, for all of us because there was an additional 2-year transitional review, which took a little over 2 years to complete, and so there's been a little bit of an overrun here. But this is a regular part of the Fair Work Act. I guess the important points from the point of view of employers are that to effect changes, the Commission's made it relatively clear that they really want to be convinced about the change. They want compelling evidence, and they're not going to lightly walk away from existing provisions, and they're especially not going to lightly walk away from existing case law which has given rise to existing award provisions. So that if you're let's use penalty rates as an example. If you're proposing to change a penalty rate regime which may have been arbitrated in the 90s, not only do you have to have compelling evidence, but you have to provide the Commission with something of a good reason to depart that early arbitrated decision. The actual process is that each award must be reviewed in its own right, but the Commission has recognised that there are some sorts of proposals for change which extend across most or all of the 122 modern awards, and therefore are hearing those separately from the contemporaneous review of each award in its own right. So we can expect that where cases are made out, there will be variations affecting awards from time to time, perhaps arising out of a common issues decision, or perhaps arising out of an award-specific review. And there'll probably be a little bit of a check of all of that at the end of the process. Some of the common issues which are coming up are a number of proposals about annual leave, and I'll briefly come back to that, and expiring transitional provisions. For example, in New South Wales, many people are still subject to the New South Wales redundancy standard, which, at least depending on the length of service, is more beneficial than that in the National Employment Standard. But the current award provision is due to expire at the end of the year. Same sort of deal with something like accident pay. There are a number of awards which provide it, but that is due to expire at the end of the year. So those sorts are going to be examined. The Commission is interested in seeing whether there can be greater standardisation of part-time and casual arrangements in awards, and that will come up sometime next year, and also with some unfinished business from the 2-year review on public holidays, mainly employee beneficial, those ones, and award flexibility provisions. Very briefly, though, talking about annual leave, a number of proposals are before the Commission, including such things as having the capacity to require someone with excess annual leave to take some annual leave. There's also a proposal for cash out of excess annual leave, for pay on cycle where employees are paid by EFT, because there are a number of modern awards which require that annual leave is paid in advance. There's a proposal that where people are paid by funds transfer, that they should just continue to be paid on the ordinary cycle. And also some suggestions to extend capacity to shut down for annual leave over the whole of an enterprise or part of an enterprise, let's say over Christmas or over the Easter period or something like that. It's in a number of awards, but not all, so those sorts of provisions are there. The ACTU is seeking provisions which would, in its view, ensure that it is clear that if someone is terminated with untaken annual leave, they're not only paid the outstanding annual leave, but also annual leave loading. At the moment, that's not a general entitlement. So they're the sorts of things which are before the annual leave common issue bench, and that is in process. The transitional provisions one is about to start. But the whole process is expected to end about the middle of next year, although my guess it will extend somewhat, but I doubt past 2015. There is a separate review of superannuation provisions, and that will have potentially quite a lot of effect on which funds are specified in at least some modern awards. I suppose the good news about that is that it's not that the provisions of that kind will not commence before the 1st of January 2015 by virtue of the statute, and they may well commence after that, but that's certainly in process at the moment. Finally, I very briefly want to talk about some changes to award obligations with respect to superannuation which came into effect on the 1st of January this year. And the key changes are that there were some modern awards that didn't have superannuation provision. All modern awards now have them. The key features of them are that where you are making a default fund contribution, that is, you're contributing for an employee who does not have a chosen fund, either a different fund from your default fund or perhaps an employee with an SMSF, then those default fund contributions have to be made into a fund which offers a MySuper product. And modern awards were varied in time for the 1st of January to be consistent with that, and that has meant that there will be some modern awards where specified funds have disappeared because they were not offering a MySuper product. There has been a couple of retrospective variations to modern awards to pick up a couple of more recent approvals, but there will be some funds which have disappeared from modern awards. Two quick points to make about this, and then I might conclude because I'm aware that Emma also wants to talk about superannuation, and that is that the obligation where an award applies to an employer is that they have to contribute for their default fund contributions into either one of the specified funds, or if they were contributing into a fund prior to the 12th of September 2008, they can continue to contribute into that fund, provided it offers a MySuper product, or a successor fund to either a specified fund or a pre-12 September fund. And if it becomes a successor fund in the future, it will, by virtue of being a successor fund, also be offering a MySuper product. But if it was a successor fund prior to that date, it does need to be offering a MySuper product. If you change your default, it's really important. None of the funds remember to tell you this. You also have to issue a standard superannuation choice form to all the employees for whom you are making those contributions. You need to do that within 28 days of the change. And if you're negotiating an enterprise agreement and you are dealing with superannuation, then the fund, once the agreement is made, if an agreement is made, by which it means voted up, from the 1st of January, anything it specifies must be a fund offering MySuper. Thank you, Ray. That's about it for me on the last year. But I wanted to end on superannuation because, unfortunately, until we get our way on this, employers are subject not only to superannuation guarantee legislation, but also indirect in the award system through the Fair Work Act. Our view is that that should be just a guarantee legislation matter and not an award matter. We haven't won that battle yet. So there are two streams of regulation, and sometimes they don't sit together as well as they might.
Fair enough. Okay, so as you mentioned, and listeners know about, there have been some major changes to super guarantee, and this has raised a number of compliance issues. So, Emma, maybe you could tell us a bit about the Australian Tax Office's approach to these issues.
Sure, thank you, Ray. So I was just going to talk a little bit about generally super guarantee and employers' obligations, and then some of the changes that have happened and are still coming for employers. So under the super guarantee, many of the listeners probably already know that an employer is required to provide the minimum level of super support for their employees who are eligible to pay their super contributions to a fund by the quarterly due date, so that's 28 days after the end of each quarter. And as Dick was alluding to, meet their choice of fund obligations for employees. So those employees who are eligible to choose a fund, an employer has to provide them with the choice to do that. And as Dick was referring to, is the default fund changes, you also have to reissue those choice forms and offer choice again. The ATO does have a range of tools to help employers if they want to understand eligibility of workers or how much they have to pay, and they're available on our website, and the address is there on that slide. Or we also have an app that people may or may not have seen already, and that's got a number of those tools on there as well. So on the bus on your way home, you can check.
And what's the app called?
I'm pretty sure if you just search for Australian Taxation Office, you will find it. So it's a whole app for the ATO. There are some super specific tools and functions on there as well. So it's important employers understand their obligations for super guarantee and work with their super funds to make sure that they meet their obligations. Where an employer doesn't make the required contribution for an employee, it will result in super guarantee charge liability arising, and that's then paid to the ATO, and we then allocate that out to funds for the members. We were asked in our question leading up to the session about whether an employer can withhold an amount of super if an employee owes them money for some other reason, and the answer to that one is no. They are separate obligations. So super is payable regardless of any other liabilities or any. So in terms of how we approach compliance with this, if we're looking for employers who might not have complied with their obligations, we have a number of ways we look for this. We have employees ring us and complain that they haven't been paid their superannuation, so we get quite a number of phone calls from people who advise us of this, and that can lead. We do look at every one of them, but that can lead to a case that we look at the employer. We get referrals from third parties, so super funds, employee associations. We get the Fair Work Ombudsman who refers cases that are high risk to us, and we get a number of other sources. Some of our other internal staff and other areas of the ATO might also refer cases that are high risk to us. We also do a lot of data matching and risk analysis through that data matching, which leads us to identify particular employers or maybe even particular industries that might be of risk, and we have a range of ways we approach that. Certainly with our industries, we try to give a lot of information, and in the lead up to taking any action, we would give a lot of information through various industry associations and newsletters and things like that, that we are paying particular attention to certain industries in a year. So there have been some changes to super guarantee rate that you referred to before. The super guarantee rate increased on 1 July last year to 9.25%, and from 1 July this year it's going up to 9.5%. Now, the government has announced in the recent budget that they intend to hold the rate at 9.5% until 30 June 2018, and then from then on it'll be increasing by 0.5 percentage point each year until it reaches 12%. So that's something for employers to keep an eye on, what the actual rate is. That's slightly different from what was originally introduced by the former government. But the intention is that it will still get to 12%. It's just over a slightly longer period of time. So it's something to just keep an eye on and make sure you really understand what the rate is in that year. The other changes that have happened is that since 1 July last year, there's no upper age limit anymore for employees. So workers who of any age now are entitled to super guarantee contributions. And the other point I was going to make that Dick covered before is that employer default funds or nominated super funds do have to be offer a MySuper product now. So if you're not sure if your fund offers a MySuper product, you should contact them and check, because you are required to make contributions to one of those products if the employee hasn't chosen their own fund or their own SMSF. Next. Some of the changes going forward are possibly people have heard them referred to as SuperStream, or potentially the data standards contributions requirements that employers are going to have to meet. These changes have been brought in to improve the efficiency of the super system and also improve the integrity of the data that is in the super system. The aim of that is to reduce the number of lost accounts, the number of accounts that people might lose touch with. They're also aimed at providing a simple and consistent way of making contributions. So employers are going to have to provide the minimum data set in a required electronic format. They're going to have to make payments to funds electronically. They're going to have to ensure that the payments and the data are linked by a unique payment reference number. And they're going to have to meet the minimum performance standards. So they're things like sending money and the data on the same day, responding to fund requests for any missing information within 10 days, and so forth. Now, in terms of the start dates for those requirements, they are still coming. The contributions aspects of SuperStream are going to start with some trials and some early preparation activities with funds and software providers from 1 July. The ATO is going to provide some flexibility on start-up dates. So large and medium employers, so those with 20 or more employees, need to start preparing from 1 July. That they can start having conversations now, in fact. But they do need to have solutions in place to meet these requirements by no later than 30 June 2015. So the smaller employers, so those with 19 or fewer employees, have until 1 July 2015 to start. And as long as they have arrangements in place by no later than 30 June 2016, they'll be all right. Obviously, if those smaller employers are ready to go earlier, there's nothing stopping them. And those employers who may be using the Small Business Super Clearinghouse will be compliant. That service is going to be compliant much earlier than those dates. So what should an employer do to get ready? They should talk to either their funds. If they use payroll software providers, they can talk to them. If they use a current clearinghouse, they could talk to them to find what solutions are available and what's going to work best for them, as well as what sort of dates those service providers are going to be ready to implement over those time periods I was talking about before. Once this starts, employers will need to provide some new information or additional information that they may not have provided before, such as key identifiers and TFNs and those things. So while this is going on, while you're preparing to upgrade to be SuperStream compliant, employers are still encouraged to use existing processes, and the most important thing is to make sure that you meet your super guarantee obligations. So if you've got a cut-off date coming up and you're not quite ready with SuperStream compliant software, or your payroll provider's not quite ready, the most important thing is still to get money into the fund at the right time. So most funds will still be accepting in that transitional period the previous way you've been interacting with them. So we did have a question in advance about transition in periods for these changes, so hopefully that's answered that question as well. So there is information available and still more being developed, so we are in the process of putting together more information. There is a web link there that on the slide, so it's ato.gov.au/SuperStream standards, and the information that's in that link is being updated as there are any changes or developments. And we are responding to questions we get through a range of groups, many of which Dick I think is involved closely in, and making sure that we update those questions that we get so that we can share them with the broader group of employers. We're also preparing an employer readiness checklist, which should be available very soon, and that should provide a fairly simple way of working through what an employer needs to do to get ready. The other thing I just wanted to mention was a bit of a plug for those employers who do have less than 20 employees to make sure that they're aware of the Small Business Super Clearinghouse. It's a free service offered by the government that helps you meet your super obligations just in one simple transaction. So it's a very straightforward, simple service that you can use to meet those obligations. So there's more information about that service as well on our website at ato.gov.au.
Great. Well, thank you very much for that, Emma. Now, looking at the clock, we've probably got time for maybe one or two questions, which I might actually aim at you, Emma, because we had a couple of interesting ones that had come through beforehand and during the webinar. Now, one question we had in particular was that someone was asking, why is it the employer instead of the super fund which has to confirm the payments? Because in theory, employers could still manipulate the date that only acknowledge receipt from the super funds as true confirmation of the receipt of funds.
Sure. So I've assumed this question, is arising when we do approach an employer to confirm whether or not they have paid super contributions the right amount and in the right time. We obviously first approach an employer because it's their obligation to pay, and it's their liability if they don't. So we do request that information direct from the employer as a first step. Obviously, we have a look at what we get in response to that, and we make some judgment calls about our perspective on the quality of that information, whether we think there is any risk. And we do certainly have the capacity and the powers to request information from a super fund to either confirm that or provide additional information if we need to. So we do approach super funds, but we do take the first step of going to an employer because it is their obligation ultimately to do that. And we hope that most employers in responding to us in those sorts of situations would be honest and provide us with a full and frank disclosure of their information.
Okay, great. Now another question just quickly, and I'm not sure whether this is more for you, Emma, or perhaps Dick, but I noticed that somebody had asked a question about super obligations for sole traders and contractors and subcontractors and that sort of thing. What's the situation with that?
Sure. So it ultimately depends on whether the workers, to use a neutral term, fall within the categories in the law that entitles them to super guarantee. So super guarantee applies not only to pretty traditional common law employees, but there are some expanded categories in the law as well that cover people who work wholly or principally for labour. They cover a broader range of some more niche categories like people performing a sports performance or performance is the wrong word, an artistic performance or performing in sporting activities, some of those sorts of categories as well. So it is important that if people aren't sure that they have a look. We do have a tool on our website that helps people work out whether their arrangements might actually fall into being liable for super guarantee. So I'd really encourage people to have a look at that. It does step people through the kind of questions that they need to consider and will guide them on whether or not they need to provide super contributions.
Yeah, fine. I just had a couple of quick things. Sure. Emma referred to the tool. The other advantage of using the tool, apart from clarifying whether or not there's an obligation, is that if there's a question down the track about whether you should have been making contributions for someone, the receipt of the tool and the information you got from the tool is evidence which you can use to support your case. Obviously, if you put in misinformation and get the right answer, that's not quite the same thing. And I guess one of the other things that often members ask is whether they can enter into arrangements where the contractor pays his or her superannuation. And really the quick answer to that is no. If the contractor is a deemed employee for superannuation, then the obligation is the employer's obligation. It's not you are paying the contractor a certain amount of money out of which the contractor will take care of his or her superannuation.
Right. Okay.
Yeah, well, thanks for that. There were a number of questions that we didn't get a chance to get to. Now, one of the things that I'd like to do as follow-up is, for those of you who are subscribers to Workplace Info, we will be producing some material on the website, maybe through our Ask an Expert area or something where we'll tackle some of these questions because they're really quite useful questions. So thank you for sending that in. So that really brings us to the end of our discussion. I'd just like to thank Julie, Dick and Emma for your time. And I trust that you've found it useful. Now, if you do have any follow-up questions, please feel free to drop us a line at editor@workplaceinfo.com.au and make sure you log on to Workplace Info or Workplace OHS for the latest information on compliance and best practices for HR, IR, and work safety professionals. If you want to revisit some of today's presentation, an archive is going to be published on our YouTube channel, which you'll be able to watch and listen to at your leisure. We'll be sending you that earlier in our follow-up correspondence. And we'll also be sending you a download pack that will give you access to some more information, some videos and checklists that will help you stay on top of the sort of issues that we've been talking about today. And our next webinar is on the 25th of July, and it will deal with money issues. We'll be providing an update on wage reviews, pay referral systems, etc. So keep an eye on your Workplace Info newsletter for more details. So I'd like to thank everyone for their time and best of luck with your work.